Mr. Darko, good evening. Thank you very much for your time. Sorry, really for the minority, I guess.
Thank you very much, Sammy. I didn't get you quite clear, but if you're asking me about the decision of the speaker, I listened to him when you were playing, because at the time the ruling was going on, I was at a committee meeting. But having listened to him clearly, I think that the speaker is right. The honorable member has filed his stay of execution, and at the time the application was made by Honorable Afenyo-Markin Referral for Ndam to be removed. The speaker clearly states that we're within the automatic 7-day stay period, and Honorable Ndam has subsequently filed a stay of execution and awaiting the judgment of the court so that he can prepare his appeal. He's also filed, in fact, the seat of appeal. So all of that really put together show that the application by the honorable member for South Dai, the Afenyo-Markin, was misconceived and premature. Sometimes I wonder why our brothers do that. I don't know. Sometimes the politics cloud our understanding of the law. But I know Honorable Afenyo-Markin knows the law very well, especially when it comes to effects of, filing stay of execution. I've always maintained that the finality of this is not there, but the cause of always, in most cases, move towards presenting the status quo. Now, as long as we understand in the case of expatriality, that when stay of execution is filed, the court expects that nothing is done to disturb the case in such a way that it will affect the outcome of the case. So I'm asking myself, if Honorable Afenyo-Markin's argument is right and the seat is declared vacant, elections are held before, for instance, the motion for stay of execution is heard, then what happens? It means that we are overreaching the court, because when Honorable Ndam filed the notice of appeal and stay of execution, he found that he cannot determine the date the matter will be heard. He cannot empanel the court. That is the decision for the Chief Justice. And so this can take some time. And if you go and hold the election after 30 days, and now they are going to hear this matter, that means that we are overreaching the court. And so on this level, I believe that the speaker was right in saying that this is not a time. And indeed, once he's filed this, once he's filed the state of execution, every other thing should stay until the matter is completely dealt with by the court. This matter will terminate at the Court of Appeal because it's a parliamentary election matter. It's not going to go to the Supreme Court. So definitely, I believe that it won't take that much time when it goes to the Court of Appeal. The three wise judges will look at it and come to the conclusion that the Tamale judge was completely wrong, and we await that decision.
So until this appeal is filed, he still holds himself as a member of parliament, and until the duration of the entire appeal, he can still consider himself to be a member of parliament for the people of Pandai.
Yes, he's a member of parliament. The people of Pandai should at all times have their representation. And the point is this: the stay of execution, okay, at this point, if you look at the fact of this case, should obviously be understood to operate as a stay of every matter. There's the application itself. Of course, you are going to wait till the matter is heard. When it's heard and the court says, for instance, imagine the court says, well, we are not going to grant the stay. Let's go and have elections. And then they set another time for hearing of the matter itself. If you set another date for the hearing of the matter itself, but the application you hear and you deny, and the election goes on, okay, and let's say a new person is elected. What if you hear the matter at another date and you come to the conclusion that, look, indeed the Tamale judge was wrong? Then what happens to the elections which were held, the resources that were wasted and all of that? And so obviously it will not serve any purpose. There's no rush. So long as Honorable Ndam is there as the people's representative. He should be allowed to stay there. Let the matter take its normal course. The court, in fact, the CJ can ask for an expedite hearing of the matter. The matter can be heard in its entirety, I believe within 3-4 months. Then the decision will come. When the decision comes from the court, and the court says that, well, they agree with the High Court judge, we can't do anything. Then we can go and have a by-election. But until then, I don't think there's any rush to declare the seat vacant. Honestly speaking, I don't understand why the judge is that, because in other jurisdiction he could have done that. Then look, this is my judgment, but hold on, if you wish to file an appeal until the appeal is heard and determined, this is my judgment, but we are holding the judgment until the appeal is, determined. But some of our judges are so much in a hurry. They are saying that elections should be held within 30 days. When the person has right of appeal, so what happens to his right of appeal? You want a new election to be held. And when you listen to the fact of this matter, it's just so disheartening that a judge can say that because some 41 polling stations had issues, somebody raised issues about some 41 polling stations, the whole 150 other polling station results should be cancelled. I mean, who does that? And we are waiting the judgment. We are told that it's going to come tomorrow. But from what we are hearing, if you go and hold an election, all the pink sheets have been signed, and you are going to collation center, and you refuse to go to the collation center, okay, and the electoral commission declares the results, how can you say that your electoral commission, by going ahead to declare the election, is a sin against the principle of natural justice? And for that matter, the whole election should be declared null and void, should be cancelled for a new election to be held. I mean, who does that? Who does that? At least we all, I can also be high court, at least by my number of years at the bar. We all read the law. For a judge to make decisions, sometimes you ask yourself, which kind of law are they reading? Especially when the Supreme Court, okay, in the Akufo-Addo and Mahama case, if you read, it seems to suggest that, look, why you have such an election and there are questions about some policies, it will require annulling the whole election. Imagine that in this country, okay, we have a national election, and about just giving 5,000 police stations, to come to conclusion that 5,000 police stations had issues. Should that form the basis for cancelling over 40,000 police stations and declare the whole country's election as null and void? Should that be the case in the Ablekuma election? Did we just run the election at the few police stations which there were issues? That was done. And the NDC won. We are living. Nobody died. This is like a case. You can't see the president from the Akufo-Addo and Mahama case. At least you can't see the president that is around. They declared that 150 police stations should all be declared as null and void just because at the collation center somebody was in there. What are we doing to ourselves?
Okay. Mr. Darko, away from this matter, but we are still staying in Parliament. Today also, the Speaker gave a ruling and more or less referred your leader, which is the minority leader, before the Privileges Committee for contempt. And I want to take your opinion on this one as well. The Speaker says your leader should be referred to the Privileges Committee for contempt.
Well, for me, I think that is a very regrettable situation. I believe that this matter could have been resolved without coming to plenary. This is Speaker's ruling. I believe that the right thing will be done. We will appear before the Privileges Committee. But let me say this. The minority members, all of us, are behind our leader. No amount of intimidation can cower us down. We will not be cowered down. We will not. We support our leader at every turn. We are behind him. Afenyo-Markin is doing a yeoman's job, and nobody can intimidate him. Nobody can intimidate the minority caucus in Parliament. Look, we have heard all the issues. Do you know that when you refer somebody to Privileges Committee, one of the things that can come out, and then one of them, is that you can be expelled from the House. You should be expelled. So are you expecting that the minority leader for his be expelled from the House? Is that a kind of democracy we are building for ourselves.
But he's not above the law. If the House believe that
nobody says anybody is above the law. I am saying is that he will appear before the privileges committee. Didn't I say that? I never said that we will not abide by the rulings of the speaker. It will be done, but I'm saying that we will not be coward. It will not happen. We will not be intimidated. It won't happen. The minority will stand strong. We will make our case known. Our voices will be heard on every matter. It is just realizing targeting the minority leader. It is just targeting the minority leader.
Mr. Darko, hold on. Why do you think they are targeting the minority leader? Indeed, he went against the standing orders of the House as the Speaker read it out in his ruling.
I am saying, my brother, the minority caucus during this whole budget debate, you should have been asking questions about the budget. This is what you should be doing. But this is what now is the news. When we have had time to debate about the budget, we've made our points so clear. This is what people of Ghana must hear, not this decision. Why this time? So I am saying that the minority will not be intimidated. Our attention will not be diverted. We are laser focused. We will present alternatives to the people of Ghana. We believe that the budget as presented is holistic. In this budget that was presented, you and I, okay, our petroleum fund, which is made up of the Ghana Stabilization Fund and Ghana Heritage Fund, is going to be wiped away under the Petroleum Revenue Management Act. The law requires that a percentage of the money from oil resources is saved for the future generation, because a large chunk is being spent today. This government now says that he wants to go and take all of that and spend it today, leaving nothing for the future generation, denying the future generation the ability to also meet their own needs, your children's children. This is an issue that must be discussed. We are not discussing it now. You want to discuss whether Afenyo-Markin is appearing before this committee. My brother, we are laser focused. We want to bring to the attention of the people of Ghana some of the excesses, some of the dangers in this budget. We want to bring that to attention. If you want to discuss that, I'm willing to stay on the line. I mean,
Mr. Darko, I'll say a big thank you for your time. John Darko is Member of Parliament for the Swame constituency and Legal Counsel for the Minority in Ghana's Parliament. This is Eyewitness News.